Hi, good afternoon, good evening. This is Kenya Rockman, the author and founder of the Child Support Hustle and the Reform Child Support Now movement. I'm gonna try to, it was like kind of dark in here, so I turned the light on, but I'm gonna try to fix it so this glare is not coming into here. Okay, I think I blocked out. Okay, so good evening. Um, as the caption says, a father was sentenced or just found out that he is on 10 years of probation because of child support debt, but they didn't even inform him prior to them sentencing him to 10 years of probation, which is ridiculous. If you want to see his video, I have it in the description, and he has the paperwork and everything. So I wanted to investigate a little bit more and find out how something like this is possible for somebody to be sentenced to probation without knowing, especially in child support court or cases. So a little bit of background. Mr. Davis, he just received notification like 2 weeks ago that he was in violation of probation. They sentenced him to 120 months failure to pay child support. So the background is in February of 2020, Mr. Davis was arrested on a contempt of court order without being offered a hearing or other safeguards that are supposed to be used prior to arrest warrants being issued. And I've talked about this over and over since 2016. There's criteria in place that they're supposed to follow before they can even issue a warrant for arrest for contempt of court. So they're supposed to screen these cases. Please don't forget to click the like button. My son would kill me if I didn't say it. Remember, these screenings were included in the Federal Register in 2016, which amended the statute 303.6 C4, which states, in order to establish guidelines for the use of civil contempt citations in 4D cases, we know 4D cases are welfare cases versus 4D cases, non-welfare cases. Thanks for liking, guys. So according to this Federal Register, before they can even issue an arrest warrant for a parent, the guidelines must include requirements that the 4D agency must screen the case for information regarding the non-custodial parent's ability to pay or otherwise comply with the order. If they can't pay, they can't comply with the order. They're not purposely failing to comply. They can't comply. So secondly, the agency must also provide the court with such information regarding the non-custodial parent's ability to pay, which may assist the court in making a factual. These contempt of court charges are not supposed to be based on not unreal evidence. It's supposed to be based on factual determination regarding the non-custodial parent's ability to pay the purge amount or comply with the purge conditions. So these are things they're supposed to be screening. Finally, the agency must provide clear notice to the non-custodial parent that ability to pay constitutes a critical question in the civil contempt action. These are just three off the top basic things that every child support agency is supposed to do before they refer a case for contempt charges. If this has not happened in your case and you are being charged with contempt of court, you should fight it. File a complaint and get those charges off of you. So none of these three requirements were executed prior to the arrest warrant being issued against Mr. Davis. He was arrested February 2020. The bail that he needed in order to purchase his freedom, because that's what we're talking about here. You basically have to buy your way out of jail, purchase your freedom. He needed $3,000 on a cash bond only. Now, because they skipped such important steps to find out if he could afford to pay or not, they don't know what his status is. If he couldn't pay to avoid the warrant in the first place, which I'm sure everybody would do because who wants to go to jail, then how could he possibly come up with $3,000 to buy himself out, but to buy his freedom. And to keep in mind, there's still no hearing. He just been arrested and put in jail. No hearing, no anything. So he spent a couple days in jail, which if you've been in jail, you know that's like an eternity, and was released after paying $125. So out of $3,000, he was able to come up with $125,000. Had not the warrant been issued, they would have known that he couldn't pay the $3,000, and he wouldn't have went to jail. So, okay, so here's where all this gets tricky with the probation. They are slick. They do not follow their guidelines, and they violate the Constitution when it comes to due process rights when they execute or enforce child enforcement. Execute child. Y'all know what I'm trying to say. They just do whatever they want. They're rogue. So the case was reset. Now, mind you, the reason why I know this is because I went and printed. These are court documents. He gave me permission to go look at this because he didn't see how he was on probation. So I went and looked at the case. Okay, let me see. I'll skip my place. Oh, I skipped it. Bad. Okay, bear with me. I'm sorry, guys. So when he was released with the 125, right, the case was then reset for a hearing on April 29th, 2020. And that was going to be concerning enforcement. And then other part of the motion was a motion to revoke, meaning the revocation of the suspended order. If the non-custodial parent does not comply with his or her support, the Attorney General down here in Texas submits a MREV. That's how it's spelled on the document, MREV, requesting that the judge revoke the suspended commitment, and the MREV may be accompanied by court's issuance of an arrest for the non-custodial parent. This is also known as a motion to revoke probation, or MTRP. MTRP is not on any of these documents that I printed from Mr. Davis's case. Nowhere. But the MRVP. I know these initials are crazy because I had to look them up. MREV, the motion to revoke, but there's nothing to revoke because he bonded out of jail. So keep in mind that there's nothing in this document discussing probation of any kind. There's only initials, and like I said, I had to look up what this meant. So I had to go to, different websites just to find out what these initials stood for. The reason that they reset the case, now mind you, on here they're resetting the hearing, and so reset is listed as a trial on the merits. So the obligor, Mr. Davis, was ordered to participate in the Choices program, and I'm going to talk to you about that. And they were also going to reset it so that the obligee could appear in court. So the Choice program, I'm going to get to that. Finally, the document states that Mr. Davis failed to appear. If he failed to appear, it may result in the issuance of an arrest warrant. Again, nothing about probation violation, or reporting to anybody for probation, nothing like that in these documents. Only that he is ordered to participate in the Choice program. So when reviewing the info showing the court dates, all the court dockets that he was supposed to appear, or where they had something scheduled, there was not even a court date listed for 4/29. There were, however, 3 entries showing the fee awarded to attorney ad litem. So the attorneys are still getting paid when all this going on. He's supposed to go to court, but then they don't put it on the docket, but the lawyers are still getting paid. And he finds out he's on probation. Nobody out of all these lawyers, all these payments to lawyers, nobody picked up the phone to call him to let him know, hey, this was from February to April. You're on probation. Nobody said anything. So his release order states nothing about probation. There's a document stating that on that day in court, activities included contempt, non-trial, ancillary hearing. I don't know if I'm pronouncing that correctly, but hey. And out of court activities concerning contempt, describes communications with client, court, attorney general's office, and the case was reset again. So this is the second reset. Again, nothing about probation, just a reset. What does that say? Hey, Morton. Exactly. How do they even get that? That's what I'm saying. We're talking about a program, a participation in a program versus probation. Probation is jail without bars. Everybody knows that. Excuse me, what's that? So let me make sure I don't lose my place. You know, I'll get to talking and I'll lose all track of what I'm talking about. But this is the stuff I'm talking about is mind blowing. So there I did it again. So on 10/7, there's another in-court activities document stating that the reason was to revoke probation again by the Title 4D office. So they trying to have hearings or saying they're having hearings to revoke probation that he's never even been notified about. Again, nothing about, okay, in the description it states, negotiation with non-custodial parent and attorney general. Let's do proposed order, but custodial parent refused to sign. So now he's not even in contempt, even if he was violating probation, because he's not refusing to sign anything. The custodial parent is refusing to sign. So how is he violating anything? Nothing about 10 years probation. On 10/15 of that date, the 4D master, what is that? It's not a judge. This is why this 4D, this whole Title 4D child support system is a fraud. A 4D master, you can see these words, master, buying your freedom, all this kind of stuff. It's a modern day slavery. So the 4D master, I can't even get over that, signed order setting another hearing. Again, no word about Mr. Davis being on probation. And I keep saying that because I'm going through the documents that I printed out. So I went through this to see where probation. You see, this is front and back. It was not in any of these documents. I saw probation online when I researched this. So the only thing that he was ordered to do was to participate in the Choices program. Again, Morton asks, who are they to even, right? So the Choice program, just so I'm clear on what it is a collaboration between the Child Support Division, the Texas Attorney General Office, and the Texas Workforce Commission. Eligible, unemployed, and underemployed non-custodial parents can be court-ordered into the program to get help finding a job. No probation. Help. That's what they're supposed to do. The program helps by providing a personal career counselor, job leads, job search guidance, career planning, support services, things like that. To be eligible, now you have to be eligible for the Choice program. When you're on probation, you are forced to be on probation. You're not eligible unless you have conditions. Okay, you eligible because you served or whatever the conditions are for the probation, but they have to tell you. They have to tell you that you're on probation. If you're eligible for it, you're supposed to know, right? So to be eligible, the non-custodial parent must be ordered by a court to participate in the program. Be unable to meet their monthly child support payments due to lack of or limited employment, which we don't know about Mr. Davis's employment or his income, because there's nothing here that he had a hearing to determine it. They must live in the county where the program is offered and must be legally able to work in the United States. So according to the Texas Workforce Commission, the court order may find the non-custodial parent in contempt and enter a jail sentence, but suspend the sentence before the non-custodial parent begins serving time. What? This is all for a job to pay a fake debt, a child support debt to the 4D child support agency with 4D masters, fake debt on a fake child support order. This is what's going down in Texas. And don't forget, Paxton, Attorney General Paxton, made big news with the record collections and all that kind of stuff. David Wright, what? Like Paxton bragged, it made billions. Not only did they steal money from the stimulus payments, they, don't pass through anything but $75 to poor families receiving TANF, $75 of the child support payment. Now we know they putting people on probation without letting them know, and the lawyers are getting paid for that. It can go on and on. So this is similar to placing a person on probation, not probation, but similar. That is from the guidelines that they put for this program. Similar to probation, but not probation. I have the links in the description. So if you want to go and look this stuff up, the Choices program, how they describe it, all that kind of stuff, and listen to Mr. Davis's video about this, you can just go to the description. Don't forget, please click the like button. Even if you watch it later, like the video, subscribe to the channel, and all that good stuff. Okay, so, I added this after I wrote all this. If you're on probation in Texas, this is what the big deal is. And they do have probation for failure to pay child support. But in Texas, for child support, that can consist of permitting a community supervision officer to visit your home, job, work, or elsewhere, and to contact employers as necessary for the enforcement of this order. So they can come and just, like any probation officer, come and violate you whenever they want, come where you are, anytime they want to. And you better be there, or they're going to send you to jail. But you have to know that you have conditions to meet for this probation before they can execute this stuff. That's why it's so astounding, and it's really bothersome. It bothers me to my core that we have so many politicians out here, and we vote and they said they're going to do this and they're going to do that, but they can't even take care of the basic needs that have to be met with this child support system in the United States. This system violates due process rights, equal rights, talking about shared parenting. They let parental alienation go unchecked, but they can put somebody on probation without even letting them know. And if Mr. Davis, right, I printed that's something else, but he has to ride around with papers to show that this issue is being addressed and everything like that, or else they're going to take him to jail. And now they're saying they revoked his probation that he doesn't even know he's on. This should not be happening in 2021. It should not have happened in the last 30 years. This should never have been allowed to happen. And we have to stop it. The politicians, if anybody's watching this, y'all have to get in there and stop all this nonsense, these violations. And you guys know that Title 4D debt is a fake debt to repay welfare that is a grant and not a loan. So, sorry, I got off script there. So again, another violation. We see them all the time. Every time I find one, I'm going to bring a video to you. I'm going to bring you the latest news that I come across, just so you know how to navigate this system. If you're going through it, if you're new to it, if you're thinking about going to it, don't even join this system. Don't volunteer to put yourself on child support. Parents, if you can, co-parent and work it out amongst you and your ex or your baby's father, whatever, what title y'all give each other. They take a lot of money just to enforce that order that could be going to your children and your household. So like I brought this down, even if you don't have a child support order, to find out that people are being placed on probation or restriction without knowledge, without due process rights, that should bother everybody. That should not just be an issue whether you have a child support order, whether you involve, whether you have children or whatever. That should affect everybody in this country. The fact that somebody can be locked up without their right to due process, for being poor. I don't know Mr. Davis's financial situation because it's not in the document. There's nothing in the paperwork. But if you are low income or you can't pay a debt, I don't care what debt it is, you should not be incarcerated. You should not lose your freedom because you are poor. Okay. So that is it for my video. Made it short and sweet as possible. I tried to stay on track. You know, guys, I know I'm rehearsing a little bit, trying to make sure I come in, give you the information without, you know, a lot of stammering and stuff like that. So I'm a work in progress as always. Thank you all for joining me. Thank you for your support. Don't forget, if you haven't already, I have a petition where we want the government to forgive the nearly $24 billion that government owed child support debt. This is money that will never go to any children. It'll go straight to the government. It's not in any way, shape, or form beneficial to children, to parents, to families at all. So if you got a second, I have the link in the description. Please go and sign real quick, share with your friends and family, tell a friend to tell a friend. To childsupporthustle.com. I have a lot of information on there, a lot of articles that I've written. Of course, you can always order my book, The Child Support Hustle, by myself, Kenya Rock Mine. I have it on ebook too. So if you see N.K. Clark or in Kenya Rock Mine, I'm one and the same. I just wrote under a pseudonym when I first released my book. You can get a t-shirt, show your support, and you can get a mask to show your support, show people that you're rocking with the Child Support Hustle, and you are in the fight to destroy the child support machine. We all deserve better. Our children deserve better, and so do their children when they have them. So I'm gonna look injustice, and where is it? That's right, Todd. How are you? That's my buddy right there, Todd. He's out of Florida. Has a great organization. Todd, if you want, put your the name of your organization in there and how people can reach out to you. It's got a great project going on. Okay, well, thank you guys for joining me and tuning in. You know, I come on random. I might start putting on like, okay, but all this stuff, this news happens so fast, and I'll wake up and see something in the morning like, oh my, so then I'll research it, and if I can, try to bring it to you guys. If not, try to get it the next day. If you have a topic that you want researched and you want me to do a video about it, let me know. You can reach me at cshustle1@gmail.com. Like I said, you can see me on, or not see me, but you can go to my Facebook page, The Child Support Hustle. Let me see, Instagram, KN or NK, and Twitter at CS Hustle, the number one. All my links are in the, you know, the thing at the top where you can click on the buttons. Okay. It's to be scratched. You're right. I agree with that, Morton. But it's taken this long to get where we are right now. And there's some serious stuff going on where they're trying to fix stuff like offer jobs programs. And this stuff they should have been doing 30 years ago. But it's too little, too late. Myself, I say throw the whole thing away. Just like when they forgave the interest to the child support debt, and I think it was Arkansas. But at this point, you knew that you were charging parents wrongly all that interest, so throw the whole debt away and don't charge it. Repeal the Bradley Amendment. Like, there's so much that's wrong. It's all flawed. But we have to go through this daily. And that's what I say. Every day, you know, people have to go through, and we got to pay the bills, and we got to do. So it's about, you know, making it. So I try to just give information to help you try to navigate so you can get the best possible outcome to a horrible situation. Jobs programs, right. Jobs, not jail. That's what they're saying now, but they are quick to throw somebody in jail. Thank you. All right, guys. Thank you so much again. Stay tuned. Make sure your notification button is clicked on so when I come on, I'm live and direct and you don't miss a beat. Remember, they can ignore hundreds, they can ignore thousands, but they cannot ignore millions. Let's go.